Hello students, welcome to the lecture on Law of Contract. After this lecture, you will be able to learn the following objectives. Define contract, explain the nature of contract, describe the classification of contracts, define essential of a valid acceptance, understand capacity of contract, explain the performance of contracts. Introduction. Now let us know more about basic concepts of contract. A contract is generally defined as a promise or a set of promises actionable upon breach of the contract. It is a legal relationship which contemplates agreement enforceable between two or more parties for the doing or not doing of some specific thing. The Contract Act only provides rules and regulation for the purpose of contract. It does not list any rights and liabilities between parties to the contract. Rights and liabilities and their manner of performance are decided by the parties themselves under the contract, but it is within the purview of the Act. Generally, courts recognize two types of contracts: express contracts and implied contracts. When an agreement is arrived at by words, oral or written, the contract is expressed. Implied contracts are divided into two groups: implied in fact and implied in law. In an implied in fact contract, the meeting of the minds is shown by the surrounding circumstances that demonstrate that a contract exists as a matter of tacit understanding. The enforceability of a contract implied in fact is based on an implied agreement and not on whether a party has received something of value. In contrast, implied in law, liability attaches by operation of law upon a person who received benefits that he is not entitled to retain. Contracts implied in law are not true contracts but quasi-contracts that courts impose to prevent unjust enrichment. A breach of contract exists when there is a failure but a legal excuse to perform according to the terms of a contract. A breach must be a material breach and must not be merely of a minor nature. A failure to perform a minor part of the contract is not considered a material breach. The amount of material breach, the non-performance of a contract, must be such as to go to the essence of the control and must be the type of breach that would discharge the injured party from further contractual duty. A material breach by one party amounts to a discharge of the other party's obligation under the contract. Meaning of contract. Let us view this video for better understanding of the topic.
So contracts. Oftentimes you hear that word and you bring to mind this nice, long, thick, dense legal document filled with words like whereas and therefore and the party of the first part. It makes you want to just pull your hair out. But the word contract actually has multiple meanings, and we're going to need to unpack those different meanings in order to fully understand contract law. The first potential meaning is the physical written document itself, the one that we looked at just a few slides back. It could also mean emails or electronic writings. So just because it's not in dead tree form doesn't mean it's not considered to be written under the law. Now, not every contract needs to be written. Of course, the problem with oral contracts is that they're not worth the paper they're written on, but they are, at least some of them, in theory enforceable. But getting back to potential definitions. So we've got the one candidate for a definition is the actual written document. Another candidate is the effective legal agreement between the parties. So regardless of what's written down, what's the actual effective legal agreement between the parties? Now, this potential definition suggests two things. First off, the expected legal agreement might not be the actual legal agreement. So what one party or both parties or all parties think in their heads is what the contract is, might not be what a judge says the contract is. The second suggestion is that we can have such a thing as an ineffective legal agreement, or a situation where everybody hires their lawyers, they write it down, they sign it, but in fact they've screwed something up or they've fallen into a situation in which there is no legal agreement. And we'll talk about those possibilities later on. Another candidate definition is an exchange of promises, and we'll be seeing that word promises quite a bit. I want to go ahead and take a look at the restatement definition, and the restatement is basically an authoritative series of books in which a bunch of very smart lawyers, judges, law professors, etc. have tried to restate the law, kind of boil it down to its fundamentals. And this is their definition. A contract is a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. Second Restatement of Contracts, Section 1. So this is quite literally the very first word on contracts, is this definition right here. So we have two definitions in there, separated by the comma, so let's unpack them one at a time. So for the first definition, starts off with promise or set of promises. So we're dealing with promises. Promises are important. The second section is for the breach of which. So breach is when the promises or the agreement is broken. So we're going to be worrying about what happens when the promises are breached. The third part is the law. So we're not dealing with what's inside people's heads, we're dealing with what the law says the agreement is, or what the law says the contract is. Final section is gives a remedy. So we're often going to be concerned with, okay, we've had a breach, what's the remedy? What can a party get by filing a lawsuit and getting in front of a judge? So kind of the bottom line off of this one is we're dealing with enforceable promises. Now our second definition, the one that's predominantly after the comma, would be a promise or a set of promises, so again, dealing with promises, the performance of which, so we're wanting to look at these promises being performed, that the law, again, dealing with what is the legal definition, not what's inside the parties' heads, in some way recognizes as a duty. So bottom line here is, again, enforceable promises. Now this phrase, enforceable promises, suggests that there's such a thing as unenforceable promises. And in fact, the general rule under contract law is that mere promises are unenforceable. We even have a special phrase for it, gratuitous promises, or merely gratuitous promises are not enforceable. So what's the key? The key is something called consideration, and we'll spend the next episode defining consideration. But if you end up exchanging consideration, then that gives you an enforceability of those exchanged promises. So the bottom line is that in order to have a contract, you need consideration or what's called a consideration substitute, because that gives you enforceable promises and that gives you a contract. So here's the credits for the two images that we've had. Again, my name's Neil Winneman. This has been a presentation of BoardGameLawyer.com. Take care.
A contract intends to formalize an agreement between two or more parties in relation to a particular subject. Contracts can cover an extremely broad range of matters, including the sale of goods or real property, the terms of employment or of an independent contractor relationship, the settlement of a dispute, and ownership of intellectual property developed as part of a work for hire. Contract. In the words of Pollock, every agreement and promises enforceable by law is contract. Section 2H of the Indian Contract Act 1872 states that an agreement enforcement by law is contract. This definition gives us two ingredients: an agreement and enforceable by law agreement. An agreement means a promise and a reciprocal set of promises forming consideration for each other. Section 2E. This definition gives us two ingredients, a promise and a consideration. Proposal. Section 2A states that when one person signifies another person his willingness to do or abstain from doing anything with a view to obtaining the extent of that other to such an act or abstinence, he is said to make a proposal. A proposal is also known as an offer. Parties to an agreement or contract. Promiser. A person making the proposal offer is known as a promiser. He is also known as an offer, or we can also recognize him as a proposer. Promise. A person accepting the proposal offer is known as a promise. He is also known as an offered. We can also recognize him as an acceptor. Enforceability of an agreement. It means an agreement which creates some legal obligation. If this agreement is not followed by any party to contract, he can be sued. Nature of contract. We enter into contracts day after day. Taking a seat in a bus amounts to entering into a contract. When we put a coin in the slot of a weighing machine, we have entered into a contract. We go to a restaurant and take snacks, we have entered into a contract. In such cases, we do not even realize that we are making a contract. In the case of people engaged in trade, commerce and industry, they carry on business by entering into contracts. The law relating to contracts is to be found in the Indian Contract Act 1872. What is a contract? The Indian Contract Act 1872 defines a contract as an agreement enforceable by law. Agreement as every promise and every set of promises forming consideration for each other. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. From the above definition of promise, it is obvious that an agreement is an accepted proposal. The two elements of an agreement are offer or a proposal and acceptance of that offer or proposal. A contract consists of two elements: an agreement, legal obligation, that is, it should be enforceable at law. Essential elements of a valid contract. The essential elements of a valid contract can be summed up as follows. Agreement. As already mentioned, to constitute a contract there must be an agreement. An agreement is composed of two elements, offer and acceptance. The party making the offer is known as the offer, or the party to whom the offer is made is known as the offered. Thus, there are essentially to be two parties to an agreement. Intention to create legal relationship. As already mentioned, there should be an intention on the part of the parties to the agreement to create a legal relationship. An agreement of a purely social or domestic nature is not a contract. In commercial and business agreements, the law will presume that the parties entering into agreement intend those agreements to have legal consequences. However, these presumptions may be negative by express terms to the contrary. Similarly, in the case of agreements of purely domestic and social nature, the presumption is that they do not give rise to legal consequences. Free and genuine consent. The consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by misrepresentation, fraud, undue influence, coercion, or mistake. If the consent is obtained by any of these flaws, then the contract is not valid. Parties component to contract. The parties to a contract should be competent to enter into a contract. According to section 11, every person is competent to contract if I, or number 1, is of the age of majority, number 2, is of sound mind, and number 3, is not disqualified from contracting by any law to which he is subject. Thus, there may be a flaw in capacity of parties to the contract. The flaw in capacity may be due to minority, lunacy, idiocy, drunkenness, or status. If a party to a contract suffers from any of these flaws, the contract is unenforceable except in certain exceptional circumstances. Lawful consideration. The agreement must be supported by consideration on both sides. Each party to the agreement must give or promise something and receive something or a promise in return. Consideration is the price for which the promise of the other is sought. However, this price need not be in terms of money. In case the promise is not supported by consideration, the promise will be nudum pactum, a bare promise, and is not enforceable at law. Lawful object. The object of the agreement must be lawful and not one which the law disapproves. Agreement not declared illegal or void. There are certain agreements which have been expressly declared illegal or void by the law. In such cases, even if the agreement possesses all the elements of a valid agreement, the agreement will not be enforceable at law. Certainty of meaning. The meaning of the agreement must be certain or capable of being made certain, otherwise the agreement will not be enforceable at law. Possibility of performance. The terms of the agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. Necessary legal formalities. A contract may be oral or in written. If, however, a particular type of contract is required by law to be in writing, it must comply with the necessary formalities as to writing, registration and attestation if necessary. If these legal formalities are not carried out, then the contract is not enforceable at law. Classification of contracts. Contracts may be classified in terms of their validity or enforceability, mode of formation, performance, classification according to validity or enforceability. Contracts may be classified according to their validity as valid, voidable, void contracts or agreements, illegal, unenforceable. A contract to constitute a valid contract must have all the essential elements discussed earlier. If one or more of these elements is or are missing, the contract is voidable, void, illegal or unenforceable. As per section 2(1), a voidable contract is one which may be repudiated at the will of one of the parties, but until it is so repudiated, it remains valid and binding. It is affected by a flaw, and the presence of any one of these defects enables a party aggrieved to take steps to repudiate the contract. An agreement which is not enforceable by either of the parties to it is void. Such an agreement is without any legal effect ab initio from the very beginning. Under the law, an agreement with a minor is void. An unenforceable contract is neither void nor voidable, but it cannot be enforced in the court because it lacks some item of evidence such as writing, registration or stamping. Contracts which must be in writing. The following must be in writing. A requirement laid down by statute in each case. A negotiable instrument such as a bill of exchange, check, promissory note, the Negotiable Instruments Act 1881, a memorandum and articles of association of a company, an application for shares in a company, an application for transfer of shares in a company, the Companies Act 1956. A promise to pay a time-bearer debt, section 25 of the Indian Contract Act 1872, a lease, gift, sale or mortgage of immovable property, the Transfer of Property Act 1882. Some of the contracts and documents evidencing contracts are, in addition to be in writing, required to be registered also. These are documents coming within the purview of section 17 of the Registration Act 1908, transfer of immovable property under the Transfer of Property Act 1882, contracts without consideration but made on account of natural love and affection between parties standing in a near relation to each other, section 25, the Indian Contract Act 1872. Memorandum of Association and Articles of Association of a Company, Mortgages and Charges, the Companies Act 1956. Classification according to mode of formation. There are different modes of formation of a contract. The terms of a contract may be stated in words, written or spoken. This is an express contract. Also, the terms of a contract may be inferred from the conduct of the parties or from the circumstances of the case. This is an implied contract. Sometimes, however, an obligation is imposed on a party by the law and an action is allowed to be brought by another party. These obligations are known as quasi-contracts. The Indian Contract Act 1872 describes them as certain relations resembling those created by contract. Classification according to performance. Another method of classifying contract is in terms of the extent to which they have been performed. Accordingly, contracts are executed and executive or unilateral and bilateral. An executed contract is one wholly performed. Nothing remains to be done in terms of the contract. An important corollary can be deduced from the distinction between executed and executory contracts and between unilateral and bilateral contracts. It is that a contract is a contract from the time it is made and not from the time its performance is due. The performance of the contract can be made at the time when the contract is made, or it can be postponed also. Classification of contracts in the English law. In English law, contracts are classified into formal contracts and simple contracts. Formal contracts are those whose validity or legal force is based upon form alone. Contracts of record are not contracts in the real sense, as the consensus ad idem is lacking. They are only obligation imposed by the court upon a party to do or refrain from doing something. A contract of record is either a judgment of a court or recognizance. An obligation imposed by the judgment of a court and entered upon its records is often called a contract of record. A contract with the following characteristic is known as a contract under sealed or by deed, or a contract of specialty. It is in writing, it is signed, it is sealed, it is delivered by the parties to the contract. These contracts are used in English law. Various transactions such as conveyances of land, a lease of property for more than 3 years, contracts made by corporation, contracts made without consideration under the Indian Contract Act also. A specialty contract is recognized if the following conditions are satisfied. The contract must be in writing, it must be registered according to the law of registration of documents, it must be between parties standing in near relation to each other, it should proceed out of natural love and affection between the parties, section 25 of the Indian Contract Act 1872. All contracts other than the formal contracts are called simple or payroll contracts. They may be made orally, in writing, or implied by conduct. Essential of a valid acceptance. There are some legal rules which make the acceptance effective so as to give rise to a valid contract. These are: acceptance must be absolute and unqualified. An acceptance to be valid must be absolute and unqualified and according to the exact terms of the offer. An acceptance with a variation, however slight, is no acceptance and may amount to a mere counter offer which the original offerer may or may not accept. However, a mere variation in the language which does not involve any difference in substance would not make the acceptance ineffective. Also, if some conditions are implied as a part of the contract and the offers accept the offer subject to those conditions, the acceptance will be treated as valid. Further, an offeree may accept an offer subject to contract or subject to formal contract or subject to contract to be approved by solicitors. The significance of these words is that the parties do not intend to be bound and are not bound until a formal contract is prepared and signed by them. Acceptance must be communicated to the offerer. The communication of acceptance may be expressed or implied. A mere mental acceptance is no acceptance. A mere mental acceptance means that the offeree is assenting to an offer in his mind only and has not communicated it to the offerer. However, if the offeree has by his conduct indicated that his silence means that he accepts, then the acceptance of the offer can be implied from the silence of the offeree. Further, in the case of a general offer, it is not necessary to communicate the acceptance if it is made by acting upon the terms or the offer. Acceptance must be according to the mode prescribed, section 7, where the offerer prescribes a particular mode of acceptance, then the acceptor should follow that mode. In case no mode of acceptance is prescribed by the proposer, then the acceptance must be according to some usual and reasonable mode. If the proposer prescribe a manner in which it is to be accepted and the acceptance is not made in such manner, the proposal may within a reasonable time after the acceptance is communicated to him insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. Agreement to agree in future. Law does not allow making of an agreement to agree in the future. The parties must agree on terms of the agreement. The terms of the agreement must be either definite or capable of being made definite without further agreement of the parties. Communication of offer, acceptance and revocation. As mentioned earlier that in order to be a valid offer and acceptance, the offer must be communicated to the offeree. The acceptance must be communicated to the offerer. Similarly, revocation of offer by the offerer to the offeree and revocation of the acceptance by the offeree to the offerer must be communicated. According to Section 4, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. The completion of the communication of acceptance has to accept, namely, as against the proposal, as against the acceptor. The communication of acceptance is complete as against the proposal when it is put into a course of transmission to him so as to be out of the power of the acceptor, as against the acceptor when it comes to the knowledge of the proposal. The communication of a revocation of an offer or an acceptance is complete as against the person who makes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it, as against the person to whom it is made when it comes to his knowledge. Revocation of proposal and acceptance. Section 5 provides that a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposal but not afterwards. Also, an acceptance may be revoked at any time before the communication of the acceptance is complete as against the acceptor but not afterwards. The English law on communication of proposal, acceptance and revocation through post office differs in some respects from the Indian law. In England, post office is the agent of the party making the proposal to take the proposal to the offerer and to bring back the acceptance from the offeree. But in India, post office is the agent of both offerer and offeree. Therefore, acceptance cannot be revoked in the English law. Sir William Anson observed that acceptance to an offer is what a lighted match is to a train of gunpowder. It produces something which cannot be recalled or undone. Capacity of contract. Who are competent to contract? Section 11 provides that every person is competent to contract who is of the age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Thus, incapacity to contract may arise from minority, mental incompetence, status minority. According to Section 3 of the Indian Majority Act 1875, a minor is a person who has not completed 18 years of age. However, in the following two cases, a minor attains majority after 21 years of age, where a guardian of a minor's person or property has been appointed under the Wards Act 1890, where the superintendence of minor's property is assumed by a court of wards. Minors contract. The position of minors contracts is summed up as follows. A contract with or by a minor is void, and a minor therefore cannot bind himself by a contract. A minor is not competent to contract. In English law, a minor's contract, subject to certain exceptions, is only voidable at the option of the minor. Held that in media, minors' contracts are absolutely void and not merely voidable. The facts of the case where a minor can be promised or a beneficiary during his minority, a minor cannot bind himself by a contract, but there is nothing in the Contract Act which prevents him from making the other party to the contract to be bound to the minor. Thus, a minor is incapable of making a mortgage or a promissory note, but he is not incapable of becoming a mortgagee, a payee or endorsee. He can derive benefit under the contract. A minor's agreement cannot be ratified by the minor on his attaining majority. A minor cannot ratify the agreement on attaining the age of majority, as the original agreement is void ab initio and therefore validity cannot be given to it later on. If a minor has received any benefit under a void contract, he cannot be asked to refund the same. A minor is always allowed to plead minority and is not estopped to do so even where he had procured a loan or entered into some other contract by falsely representing that he was of full age. It is to be noted that if money could be traced, that the court would have an equitable grounds ask the minor for restitution, as minor does not have a liberty to cheat. A minor cannot be a partner in a partnership firm. However, a minor may, with the consent of all the partners, for the time being, be admitted to the benefits of partnership. A minor's estate is liable to a person who supplies necessaries of life to a minor or to one whom the minor is legally bound to support according to his station in life. The English Sale of Goods Act defines necessaries as goods suitable to the condition in life of the minor and to his actual requirements at the time of sale and delivery. From the above definition, it is obvious that in order to entitle the supplier to be reimbursed from the minor's estate, the following must be satisfied. The goods are necessaries for that particular minor having regard to his station in life or status or standard of living, and thus purchase or hire of a car may be a necessity for a particular minor. The minor needs the goods both at the time of sale and delivery. What is necessary to see is the minor's actual requirements at the time of sale and at the time of delivery, where these times are different. The minor's estate is liable not only for the necessary goods, but also for the necessary services rendered to him. The lending of money to a minor for the purpose of defending a suit on behalf of a minor in which his property is in jeopardy, or for defending him in prosecution, or for saving his property from sale in execution of a decree, is deemed to be a service rendered to the minor. Minor's position under English law. In England, one who has not attained full age is treated as an infant or a minor. Infancy under the English law means the period of life which precedes the completion of the 21st year, and persons under that age are regarded as infants. Contracts entered into by an infant are classified into the following categories: void contracts, voidable contracts, valid contracts, contracts enforceable at the option of the infant but not at the option of the other party. Void contracts. Section 1 of the Infants Relief Act 1874 provides that the following three types of contracts, whether specialty or simple, are void. Any agreement for the repayment of money lent or to be lent. Any contract for goods supplied or to be supplied other than necessaries. All accounts stated. Voidable contracts. In this category of contracts, the position is that they are binding upon a minor unless he repudiates them before he reaches the age of majority or within a reasonable time thereafter. Some such types of contracts are contracts of a continuing nature, contracts under which a minor acquires an interest in property of a permanent kind, example, leases of property, partnership agreement, agreements to take shares which are not fully paid up, valid contracts. An infant is bound by such contracts. Contracts for necessaries, contracts for the minor's benefits such as for his education, training, etc. Mental incompetence. We have seen earlier that one of the essential elements of a valid contract is that the parties to the contract must be competent to contract, and a person must be of sound mind so as to be competent to contract. Section 10 to 11. Section 12 lays down a test of soundness of mind. It reads as follows. A person is said to be of unsound mind for the purpose of making a contract if at the time when he makes it he is incapable of understanding it and of forming a rational judgment as to its effect upon his interest. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. Soundness of mind of a person depends on two facts: his capacity to understand the terms of the contract, his ability to form a rational judgment as to its effect upon his interests. Lunatics. A lunatic is a person who is mentally deranged due to some mental strain or other personal experience. However, he has some intervals of sound mind. He is not liable for contracts entered into while he is of unsound mind. Idiots. An idiot is a person who is permanently of unsound mind. He does not have lucid intervals. He is incapable of entering into a contract, and therefore a contract with an idiot is void. However, like a minor, his properties, if any, shall be liable for recoveries on account of necessaries of life supplied. Also, he can be a beneficiary. Drunken or intoxicated person. A person who is drunk, intoxicated or delirious from fever so as to be incapable of understanding the nature and effect of an agreement or to form a rational judgment as to its effect on his interest cannot enter into valid contracts will such drunkenness or delirium last. Incompetence through status. Beside minors and persons of unsound mind, there are some other persons who are incompetent to contract partially or wholly, so that the contracts of such person are void. Incompetency to contract may arise from political status, corporate status, legal status, etc. Performance of contracts. A contract creates obligation. Performance of a contract means the carrying out of these obligations. Section 37 requires that the parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provisions of the Control Act or of any other law. Offer to perform or tender of performance. It may happen that the promisor offers performance of his obligation under the contract at the proper time and place, but the promise refuses to accept the performance. This is called as tender or attempted performance. A tender or offer of performance to be valid must satisfy the following condition. It must be unconditional. A conditional offer of performance is not valid and the promiser shall not be revealed thereby. A tender is conditional where it is not in accordance with the terms of the contract. Who must perform? The promise may be performed by a promiser himself or his agent or by his legal representative. Promiser himself, if it appears that it was the intention of the parties that a promise should be performed by the promiser himself, such promise must be performed by the promiser. Agent. In cases other than the one specified in 1 above, the promiser may employ a competent person to perform it. Legal representative. In case of death of the promiser, the legal representative must perform the promise unless a contrary intention appears from the contract. Contracts which need not be performed. A contract need not be performed if the parties mutually agree to substitute the original contract by a new one or to rescind or alter it. Section 62. If the promisee dispenses with or remits wholly or in part the performance of the promise made to him or extends the time for such performance or accepts any satisfaction for it. Section 63. If the person at whose option the contract is voidable represent it. Section 64. If the promisee neglects or refuses to afford the promiser reasonable facilities for the performance of his promise. Section 67. Now in the end, let us summarize what we have learned in the lecture. The Indian Contract Act was passed and implemented to control various kinds of commercial and business contracts. An implied contract is a contract which is made otherwise than by the word spoken or written. It came into existence on account of an act or conduct of the parties. The acceptance must be absolute and unqualified. Unqualified means unconditional. The acceptance must be for the whole offer, including all its terms and conditions, if any. It may be noted that conditional acceptance will result into a counter offer. A breach of contract occurs where a party to a contract fails to perform precisely and exactly his obligation under the contract. Renunciation occurs where a party refuses to perform his obligation under the contract. A contract is generally defined as a promise or a set of promises actionable upon breach of the contract.